Hello everybody, my name is Natalia Willette and I am a real estate and estate planning attorney here in the state of Florida. And today I wanted to talk to you about foreclosure sales. And the subtopic we're covering today on foreclosure sales is homeowners association and condo association liens. Do they survive or do they not survive? What happens at the foreclosure sale? So one of the biggest misconceptions people have is that because HOA liens and condo liens get wiped out at tax deed sales, that somehow they also get wiped out at foreclosure sales, but that is simply not the case. When the purchaser at a foreclosure auction is a lender, then it triggers a safe harbor provision, but that is only effective as to the lender. And that one essentially limits the association's dues to the last 12 months or 1% of the final judgment amount in favor of the lender. What does that mean for you? Well, it means that if you're a third-party bidder at a foreclosure auction, you are not necessarily going to get any benefit in terms of the HOA dues. Why are HOAs named as defendants in these foreclosure suits if their interest doesn't get wiped out? That's an excellent question. The reason why is because if the lender becomes a winning bidder, if they fail to name the association as a defendant, then they're not entitled to those safe harbor provisions that limit the amount of assessments owed to that 12-month period. That's why. But they're not otherwise erased, deleted, or anything else from your obligations as a third-party purchaser. So if you purchase a certificate of title from a mortgage foreclosure sale and there's an association lien that ran with the property, or a condominium lien that ran with the property, or just past due assessments for which they haven't recorded a claim of lien, you are liable for all of that. You're jointly and severally liable with the prior owner for that, unless the restrictions of record for that particular association, whether it's a homeowners association or condominium association, has said that they are more generous no matter who is the purchaser at a foreclosure auction. And there are still associations that have much more generous, let's say, restrictions of record, or condominium declarations, association declarations that are more generous to buyers. So they can, for example, extend that 12-month period limitation to all buyers at a foreclosure auction, or they can say that nobody that buys at a foreclosure auction has any liability for any past due assessments, that they just get a clean slate. And there have been cases in which I've represented clients where the association was trying to claim back owed assessments. We took a look at their restrictions. Sure enough, those restrictions said, oh no, nobody that buys at a foreclosure auction, whether it's a lender or a third-party purchaser, has any liability for any assessments due prior to that certificate of title being issued. And guess what? It was like receiving nice, clean title from the perspective of association dues. So it is very important that if you see these associations as named defendants, you take a look at those restrictions before you bid. You might be pleasantly surprised, or you might be ready to surprise yourself unpleasantly, but should be able to say, okay, I need a bigger cushion in what I'm bidding. I need to make sure that I have maybe $20,000 in cushion from what I would normally bid for this to pay for association dues. If you want more videos like this on foreclosure sales, tax deed matters, eviction proceedings, or estate planning questions, subscribe to our channel. My name is Natalia Willette, and I want to say to you, good luck out there, investors.